OSHA has their eyes on you, and plaintiffs' attorneys hope you won't read this message. Let's talk about the importance of workplace violence prevention training. What is workplace violence? Workplace violence is violence or the threat of violence against workers. It can occur at or outside the workplace. It ranges from threats and verbal abuse to physical assaults and homicide. It's one of the leading causes of job-related deaths, and it's a growing concern for employers and employees nationwide, according to the U.S. Bureau of Labor Statistics. What is OSHA's interest? Section 5, Paragraph A, Subparagraph 1 of the OSHA Guidelines, which is referred to as the General Duty Clause, requires employers to provide a workplace environment that is, quote, free from recognizable hazards that are causing or likely to cause death or serious harm to employees, unquote. So what is your liability if you fail to train? Recent court rulings throughout the country have allowed negligence suits filed by victims of active shooters to proceed against employers for failing to provide defensive training to their employees. In other words, companies can no longer avoid their corporate responsibility to provide training on both how to spot potential active shooters and violent actors and on how to react if so confronted. Let's take a look at two lawsuits that will illustrate this point. A small company takes a big hit. The family of a man killed in a 2012 office shooting at Accent Signage Systems in Minneapolis has reached an undisclosed settlement with the company, according to an attorney and an order filed by the Minnesota Court of Appeals. Jacob Beneke, 34, was one of 6 people killed by Andrew Engeldinger on September 27, 2012, before Engeldinger took his own life. 3 other workers were also injured in what became the deadliest workplace shooting in Minnesota. Beneke's family sued Accent Signage, alleging the company should have known from Engeldinger's work history that he was potentially dangerous. The court said there was enough evidence to allow a jury to decide if the employer was grossly negligent in how it handled the employee's termination. Evidence included, but was not limited to, the fact that the employer knew the employee had a propensity toward violence, and that the employer knew or should have known that the employee might act out against others in a manner likely to cause physical harm. Workplace violence doesn't have to be deadly, or even physical, as we'll see in this next case. In the case of Harris versus Thomas Marine Construction, the employee alleged that on numerous occasions between December 9, 2009 and February 25, 2011, the company owner committed workplace violence and created hostile working conditions. He allegedly behaved abusively, made inappropriate sexual comments and advances, yelled, screamed, and made physically threatening gestures in addition to withholding the employee's paycheck. The employee, who worked directly for Thomas, reported to him that he was creating hostile conditions. On February 25, 2011, the employee filed a timely whistleblower complaint with OSHA, alleging discrimination by Thomas for having reported the conditions to him. On March 28, 2011, Thomas received notification of the complaint filing. On March 23, 2011, Thomas had computer passwords changed in order to deny the employee remote access to files and then terminated the employee. OSHA's subsequent investigation found merit to the employee's complaint. The reality is that defending a lawsuit is expensive. Defending a case through discovery and a ruling on a motion for summary judgment can cost an employer between $75,000 and $125,000. If an employer loses summary judgment, which, more often than not, is the case, the employer can expect to spend a total of $175,000 to $250,000 to take a case to a jury verdict at trial. Most employers will choose to retain an employee instead of assuming the risk of a $250,000 legal bill with an uncertain outcome. Moreover, employers cannot avoid this risk simply by settling every claim that is filed, lest the company risk the perception of being an easy mark by every ex-employee. Lessons learned. It's better to apply them now. Failure to provide an effective workplace violence prevention program can put your employees at risk of harm or death, open the door for lawsuits that can cripple your company, and results in negative publicity that can affect your sales and service. However, benefits of providing an effective workplace violence prevention program demonstrates a proactive approach to employee safety, provides a sense of security that contributes to overall employee satisfaction, and employee production is positively affected. These courses are specialized. Browse the library of courses to find the ones that meet your specific needs. The Workplace Violence Prevention Training Program was written for company owners, supervisors, management, and human resources personnel. Other active shooter response and survival courses were written for employees in the workplace, medical setting, and college campus, as each environment has its own challenges. Most workplace employees should enroll in the classic Run, Hide, Fight course. It's time to take the next step. Enroll in the relevant EZ Class courses. For a list of courses related to security and workplace violence, go to the Anti-Terrorism and Security Training block at www.ezclass.us. For a brief overview of EZ Class, go to www.ezclass.biz and click on the blue box. Many years ago, a wise and famous man once said, "An ounce of prevention is worth a pound of cure." Don't delay. Your proactive approach will save lives, promote a safer environment, and reduce your risk of a lawsuit. For more information, including discounts on learning packages, group enrollment, and a free sample course, contact Frank Margolis at frankm@cateyes.us or call 609-521-4446. Also, we can create custom-designed courseware for your particular needs and interests. Thank you, and goodbye.